Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel Lusak. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
Hi, I'm one of your hosts, Elizabeth Morris, Senior Director of IP and Product at Everpure Incorporated. In my role, I manage the patent portfolio at Everpure. Let's go ahead and dive right in.
With a new hardware release, evaluating the design for potential patent protection is a fairly standard process. Designers are usually familiar with your previous designs and what is on a competitor's tool. You analyze the value of the component, you check the prior art, and you're done. While the steps are the same, doing this for software can be a little bit more challenging. Part of this is the intangible aspect of software versus hardware. Part is the difficulty knowing all your competitors when for software all you need is a laptop. Some may be the ease of keeping software as a trade secret, and some may be a cultural hesitancy among software developers against pursuing patent protection. On this episode, we will evaluate how to improve an invention disclosure collection or harvesting process when it comes to software inventions. Elizabeth and I are joined by Karl Barnfather to learn more. Karl, welcome. Would you mind giving a quick introduction to start off this episode?
Not at all. Hello, everybody. Thanks very much for having me. I'm a patent attorney based in Europe. I'm actually based in the UK, you'll possibly tell from my accent. I've been working for 30 odd years now and predominantly in the software sector, not least, of course, thinking about it, since the State Street Bank decision of 1998 at the Federal Appeals Court. It was a landslide decision and led to a huge growth in software patents, not just in the US, but over here in Europe. And of course, more recently, the last 8-10 years or so in machine learning and artificial intelligence innovations. So I've got a background as a PhD physicist, but as I say, really working in high tech across many software areas of innovation, and qualified European patent attorney, a British chartered patent attorney, and a UPC, which is New Court, the Unified Patent Court representative, of which I have some actions ongoing presently. And if I may just proudly boast of having done over 100 hearings at the European Patent Office at all instances, from examination division at first instance, opposition division first instance, as well as technical boards of appeal, and even at the enlarged board of appeal.
Karl, it's so good to have you on. I just have a personal interest in UPC, so I may need to bend your ear actually after this podcast as well. But, certainly my own background has also been very, I think, based on the proliferation of software patents over the course of my professional career. So really interested to dig in with you today. Just to start off with, my first question to you is, what challenges do companies face when gathering invention disclosures that are related to software?
I think the first one I would highlight is a cultural one. Software engineers, developers, coders, come from an environment where they're used to sharing, particularly those, of course, that do work actively in open source software. So there's often cultural impediment with engineers to think of something as being proprietary to them in a patent sense, from my perspective, from my experience. So the cultural piece is really, and a lot of what the points I was going to make in this section of our conversation would be a bit around communications and the way that there's that communication with those software engineers really informs at all levels, not just from a patents manager or in-house patent counsel, but from all levels of the C-suite throughout the company in terms of encouraging protection. And we see this particularly in Europe. I don't know to what extent it's significantly different in the US. It might be, culturally, there's a greater acceptance of the need for intellectual property and patents that are something which companies reach for much more readily than they seem to in Europe, which we see from patent filing numbers, for example. So I'd say the first piece would be about cultural, breaking down those concepts of sharing and really getting an engagement from, as I say, software engineers, software developers to make innovation disclosures. And I think that's another point. So part of the communication thing is their innovation disclosures as opposed to invention disclosures. I think it's quite rare that developers, coders think of something they've done, a piece of code or a system, a process, as being an invention and thinking about an invention disclosure. So what I've encouraged clients for a long time to do is, as outside counsel, is to think about, communication related to innovation processes and innovations within product lines, and trying to capture those innovations through an innovation capture rather than an invention disclosure process. So that you're just trying to help the process in what are quite small things in themselves, but what you're trying to build, as I say, is a culture of disclosure into management, without which you've had it, haven't you? As the IP manager, you're not going to file anything unless you're getting the engineers to come forwards with some kind of disclosure. One of the tricks, for example, one of my clients, an ML developer, did, and it was the in-house counsel found that by changing the concept of invention disclosures and patent management committees over to a publications committee, and getting publication disclosures submitted by her engineers, her colleagues in the development sections of the business, because there's an awful lot of people working in machine learning and AI development who have ties with academia. A lot of companies are hiring academics, and there's still that desire by many of those, of course, to publish, and to publish in peer review articles, and to be, that's commensurate with their career goals. And it's not necessarily a clever idea to cut those goals off and to play along with those. So what she found was that by encouraging the idea of publication and talking about publications committee, and obviously having the right of veto, as the paying employer to say no, but in some instances saying yes, there's a publication here, but you've got a disclosure, albeit that it's in a different format. It's not in what we would regard historically, as Nathaniel talked about at the beginning, of a product disclosure. It's come in as an idea for a publication, for a peer review article, and from which you can extrapolate and or interpolate whatever the relevant information for a possible patent application. And of course, what a publications committee is then doing is it's identifying ideas which they're happy to go into public domain. It then drives a deadline for filing the patent application, right? And you're not just going to sit on it. So the one thing you've ruled out there in that scenario is if it's got the green flag for publication in a peer review article, it ain't going to be kept as a trade secret. So it's one or the other. It's either public domain, free for others to use in the academic article, or you get the patent in before. And of course, from a European perspective, we've got absolute novelty, and you need to file before that paper publishes, and preferably before it goes out the building, I would suggest, in spite of non-disclosures, etc. Yeah, so there's some thoughts, cultural ideas, how to engage, and I think, as I say, it comes down to how to engage your software developers, your software engineers in that process. The idea of disclosing to management, and I think another piece is not just that they're not used necessarily to thinking about it from an open source, coming from a sharing type mentality, but also the regard as in other sectors, but particularly true in software. Whereas, well, I just coded it. I just wrote some stuff. It's fairly trivial with hindsight, and they don't necessarily regard it. And is there? And I think this is possibly more of a European concept than a US concept. I haven't particularly had a eureka moment. I don't feel like Mr. Edison and having invented a light bulb. I just feel I've done it's my part of my job. So again, that's the cultural thing to overcome and get disclosures as part of a process, engaging with teams, having champions within teams who are better informed about IP. I think there's a myriad of things, aren't there, which I'm sure you're both familiar with, that you need to do. There's not one silver bullet, one particular thing that you can do. As I say, from my perspective, it comes down to very much a culture within the various teams.
I hear you on the cultural piece, and you have to bridge that divide. And besides slapping a new name on it and calling it an innovation disclosure instead of an invention disclosure, what's your recommendation for how a company can improve the number of invention or innovation disclosures and the quality of software-related disclosures that come in for evaluation by the legal team?
So I think the obvious one, because it exists and it's been applied for years in different sectors, is incentive schemes, right? So financial, it's part of some greater benefit that isn't just your pay packet. There's a supplement somewhere. And incentive schemes, as you will be aware, range from patent walls in companies, different organizations. Literally the first thing you see when you walk into the reception of the headquarters is, are framed patent documents, and employees take great pride on family days or whatever to point to their patent that's got their name on it to their friends and family and so on. And that's genuinely a great thing. And I think historically that stemmed from a sort of more Japanese culture of pride in what you do than necessarily financial reward. But it's been adopted, I think, quite widely in US and Europe as well, amongst many companies. But, and it doesn't necessarily have to be a high financial reward, but there are many schemes out there which will provide, and I think typically they some financial benefit, and they typically spread the remuneration, which I think typically might range from anything from 2 to 5 or so, thousand US dollars or more, a bit more, but they're not massive amounts of money per inventor, or they might be a fixed sum split between as many developers as there are on the actual disclosure, and they come at different stages. So you're encouraging them with a decent amount of money up front, and then if it gets past the patent review committee or the innovations review committee, the publications committee we've been talking about, then it might be another sum of money, and then there might be another sum of money when the patent application gets published and or granted. And so there's lots of those schemes, and there's no one formula for what's the best. And some people use a bit of both, the pride patent wall and financial reward as well, of course. Beyond that, I think one of the things that software itself is helped with is using AI LLM tools themselves, has made it easier for developers and software engineers to generate a document. Arguably, they're used to writing in Python and or not entirely natural language systems, and so a natural language script, for want of a better word, document that's generated by an LLM makes it a lot easier. I mean, I know this firsthand. It's taking a lot of training as a physicist that didn't used to write much apart from formulas and equations and so on, work in a lab, to become expert in writing prose and comprehensible documentation for courts, etc., and patent offices. That is a hindrance for software engineers generally, or can be, not necessarily everyone, but it's just one of the factors. So LLMs and other tools, the format of the innovation disclosure document, having it with specific questions to be answered rather than just being a blank. What's the innovation? How is it better over the prior art? Having much more detailed questions. So thinking about, for example, in the machine learning stack, to ask about not just what's the overall invention, but what improvements have you done in terms of data management, data filtration? What percentage of your data are you using as training data and test data? What training methodologies are you using? Which algorithm? Specific questions at each layer of training methodologies, fundamental learning tools, etc., that are being used. What specific benefits do you see from what you've used versus what alternatives are? And so if you break down the stack, for example, in machine learning, and ask specific questions at each level, then that, I think, helps encourage the developers to come forward and provide some pertinent detail, rather than what we often get, of course, is you either have too abstract a disclosure in a document, or you get the code at the other end, and neither of which are any good to us, right? So it's getting that middle ground, and so I found that the tools are extremely helpful, actually, and they are coming forwards, and I think of themselves, and I hear this from in-house counsel, that is beneficial, and we've had excellent feedback historically from major US tech companies as well, that this approach of not just providing a blank or generic innovation disclosure, invention disclosure document to engineers, and treating software developers in the same way as engineers were historically, but giving them context of, well, we understand you're working within this environment where you've got data issues, you've got training algorithms to think about, you've got platforms to think about, you've got neural networks architectures to think about, you've got weights and parameters and all sorts of other conditions you've got to think about, actually asking specifics within the stack itself, and not just what the final model does and how clever it is. It actually helps them, and it helps us as patent attorneys ultimately by having a far better disclosure for the purposes of filing a patent application. We published a paper in Intellectual Asset Management, IAM magazine, about 3 or 4 years ago now, where we analysed some 3,000, so there's myself and some former colleagues, some 3,000 office actions at the European Patent Office related to 1,800 published ML-related patent applications. And I think something that's relevant for later on in the conversation is that 50% of those patent applications related to stuff that sits behind firewalls that could have been kept confidential and trade secrets. 50% related to models and end products that were arguably much more visible in the public domain, applications on iPhones or whatever, or sensor methodologies on autonomous vehicles, etc., or where they arguably were reverse engineerable. That's one point that we may come on to discuss later. The other point, though, related to getting good disclosures, more and better disclosures from inventors in the first place, is that back then, 3 or 4 years ago, stuff that was obviously filed back in 2018, 2020 sort of time frame, so being published in the early 2020s, 3 or 4 years ago, was naive. And they were getting a huge number of 10% of all those cases that we analyzed, 10% of all those office actions, 3,000 office actions, actually had a lack of sufficient disclosure, a lack of enablement, or potentially written disclosure objection. And it was as high as 10% of all cases, because naively the patent drafter had pointed to, well, there's an AI system back there that did something clever, and here's the model, here's the outcome. And it was especially true when it was mixed, when there was an outcome that was being sought to be patented, and there was a disclosure about how the outcome, the model, the working model that had been derived, which methodology itself was not disclosed. There's quite a few patents, as I say, out the 3,000 office actions that you could point to and find fairly straightforwardly, or the examiners have just simply said, well, that disclosure saying you use a convoluted neural network is not good enough. That's leaving the engineer, the reader, the third party, with an impossible task to recreate your invention. So Article 83, lack of EPC, European Patents Convention, objections for lack of sufficiency were quite rife. And so that was one of the things that prompted us to say, well, how do we get better disclosure? And I think that will have improved generally. Anyway, I mean, I think all patent attorneys, or those of us practicing this sector, have become better aware of what we do need as case laws developed and so on to disclose. And of course, getting that right in the first place from the relevant innovation disclosure by prompting, by want of a better word, the engineers themselves, software developers, to give us the right information in the first place is clearly key.
Thanks, Karl. Yeah, I really love that idea of prompting and questioning the inventors along the way as they're submitting these disclosures, and making sure that you're, basically not just using a generic disclosure form and saying, "What did you what are you doing?" Right? But giving them something a little bit more, I think could be really helpful. So, in your experience, how does the approach to harvesting software inventions differ from hardware inventions specifically? And how should the process change for those software inventions?
The process is quite different, isn't it? And it seems to me, I don't know what the term is. I'm trying to think. It's much more of an iterative, continuous process, software development. I think, compared to a bit more sort of musical term, for want of a better one, staccato process of step forward, then another step forward, as opposed to continuous. And I've been involved, and it's the worst case scenario I ever had with an AI related invention was I was presented with the committee of all the developers to talk to and try and get input, because everyone had an input, and it was just, I suppose, what they felt. This was a number of years ago, but none of them really had a feel for an oversight for the whole thing. They'd all chipped in their bits, and no one felt confident to say what the overall development was, and it just made the whole process extremely difficult. So having someone that really can sit there as the lead developer, which hasn't always been the problem, but this is a scenario that did occur to me at least once, and it was a number of years ago, who is the IP champion, is extremely helpful, which I think you get more in engineering, mechanical type engineering, product engineering. That there's a lead project engineer much more straightforwardly, perhaps, and there's a more natural rhythm to the development, where you might have a prototype that's a specific thing that then gets developed, and there might be better occasions. I mean, this is trying to contrast two things for the purposes of the extremes, because there will be very, very similar development processes as well, obviously. But fundamentally, I think there is that problem of teams working on different individual points, trying to gather those points together when they're being continuously iteratively developed within the concept of the software development, and having that then someone sitting and being able to take the helicopter view of what's going on and provide us with the relevant information, that it isn't just point A within this particular section of the code or this part of the process, but actually these things work synergistically. It's a very overused word in our sector, isn't it? But synergistically, they work together for the overall process. And having that person that sits there and tells us what that is it extremely helpful. And sometimes, in my experience, that can be missing because of the nature of the development process. So that'd be one thing I'd point to, I think. We've just been talking about the nature of the, what is it? What is the big idea? And getting that written down again, I think stems that's possibly the same point really, that with hardware development, it's this X-ray machine, and it has better or lower power consumption and better focusing ability on whatever, better data analytics, better image resolution, whatever it is. There's something they're pointing very, very specifically to something, which, as I say, doesn't necessarily, and that's I think oftentimes more easily explained in a disclosure to the patent team than necessarily it would be in software, certainly in the beginning. And I think and then maybe that's because, does that arise because we've been patenting hardware stuff for a long, long time, and the engineers are used to it, and it's and software development and ML, AI, and these people that have come into it, of course, they're not all coders, they're not all computer scientists by background. They're hybrid teams, aren't they? Various people with various skill sets. And is that a potential? They're not like-minded. It's different, I think. Different clients. Coming back to my first point, cultural. How can we help them? Because there is definitely an issue in software, harvesting software inventions. To your question, the better that the in-house patents manager, the patents team, the innovations team engages with them and identifies whatever the problem might be for a specific team of engineers, company, division, whatever, the better for them. And I don't think it's necessarily one specific thing that's going to be the hurdle for them. Definitely historically there's been a divide, and whether that's improving significantly, as I say, from the use of the ML tools, the language models tools, the LLMs that are now available, subject to corporate policies and disclosure, and making sure that stuff remains confidential within the organization. That the use of those has certainly helped expand disclosures and the quality of those disclosures.
So let's assume we've improved the process. We've taught the innovators, we've done everything we can, and now there's a good solid pipeline of innovation that's being documented and submitted. One of the traditional hesitancies is patenting versus trade secrets. You mentioned earlier that if you had a publication committee, then that eliminates the potential possibility of just keeping something as a trade secret. But how should a company approach the issue of balancing a desire to gain patent protection on its software versus keeping its developments as a trade secret?
Yeah, I think it's a hugely interesting question, hugely interesting subject, and I don't think there's a right answer, is there? It's policy. I personally know an in-house counsel that I respect hugely, whose policy, significant corporation, is that anything that can be kept trade secret, but sits behind a firewall, sits as an industrial process behind physical walls, will be kept as a trade secret and not patented. And there's a financial imperative to that. We're saving on patent costs. I'm not sure how binary that is, because of course there is a cost to managing trade secrets. And I think that's not necessarily widely understood. I think many corporations, just thinking about the whole subject of trade secrets for a moment, certainly we are told from the US Council always tells us that, or pretty much, I think, certainly the vast majority of the US Council will tell us, don't keep registers of trade secrets. The risk being that the trade secret that you want to assert, first hurdle you're going to have is the other side saying, well, you've not managed it as a trade secret because it wasn't identified in your list 2 months ago. It's only been added, in the lead up to this litigation. And so it wasn't, so that's the first defense from the other side in a trade secrets claim. So, and that's one perspective, I think. And I don't know that that's necessarily universally held, as I say, but that's certainly the advice we get from the US, from many, many US counsel. And yet you've got this innovations capture system going on, which you then potentially identify some as being going to be kept as trade secret. So how that's managed in that scenario of not having a catalog, I don't know. So that's a complication. But that's certainly should be one of the outcomes, is that this is certainly confidential information and should be treated as such. Identifying which is which, patents versus trade secrets. Coming back to the data I mentioned earlier, published in the IAM magazine in about 2022-23, of those 1,800 patents that we analysed, as I say, 50% of them related to innovations which could have been kept as trade secrets because they related to stuff entirely sitting behind the firewalls in the ML stack and not the model that was in the public domain, from which you might infer certain functionality, but not necessarily guarantee knowledge of a functionality that sat behind the firewalls, exactly what the algorithm was, what the training data looked like, etc., etc. So, and they could have been kept as trade secret. And yet, many, many different major corporations had sought to patent those So as I say, it's policy, not a defined logical decision. And what's the policy for those companies that are filing those patent applications? Presumably it's that they want something. We don't know what, of course, number of patent filings are generated, what that 900 cases out of the 1,800 cases represents in overall innovation disclosures to the specific company. Whether it's 10% of all disclosures or 50% of all disclosures, we don't know. But anyway, it's a number that are being disclosed, which could have been kept trade secret, but as far as patent applications get published, get taught to third parties. And so what's the benefit? There must be some, right? There must be at least perceived benefit. And whether that's in terms of the particular companies, we're talking major corporations in many instances, household name corporations that are doing this. And presumably it relates to their particular strategy, whether they want to be seen to be patenting in that subject area, having expertise, whether they've been giving kudos to their engineers, the software developers, by being named as inventors on patent applications, whether it's an exit strategy for different companies in terms of sales, that investors do like to see some kind of patent portfolio as well as trade secrets and are nervous about exclusive trade secrets holdings. Who knows? I think there's a myriad of explanations as to why you might want to get patents for those inventions or innovations that could nevertheless have been kept a secret. So then it comes to the point, well, how do you then determine? You have a policy, you needed a policy, clearly. You know, as a company, you need to decide, well, are we going to have exclusively a trade secrets policy or not? Are we going to file some? What sort of budget do we apply? And then how do we reach a decision? And that's that patents committee that we're all familiar with as patent attorneys, the in-house patents committee, which we often invited to join and help with, certainly in the early stages of a company developing its, methodology for making these decisions. And then it's for the company, isn't it, to decide what its criteria are as to what it goes through. And we've certainly helped develop questions where, and weighting the answers to those questions. And I think typically I would encourage companies to think about something in the order of 15 things that they think about as to what's important, as to whether they patent, keep trade secret, or in fact, publish for release to the public domain in the old IBM Gazette style of releasing to the public domain. That there's something in the order of 15 odd questions, whether it's 10 to 20, but certainly not too much, because you've got to get your engineers to help you go through this, right? And you want to encourage them in this process, not discourage them. And to weight those answers as to relevance to your own particular IP policy and where the strengths are, whether that's, in terms of how defensible is it, how, what's detectability like for an infringer, how broad is the protection, how defensible is it in terms of novelty, what's the financial model, where's the product, what is the product line, where is remuneration, where is profit coming from, is it in licensing, who are the licensees? There's a whole bunch of financials. There's various sectors that you would typically have in that questionnaire that management can go through. As I say, we've helped companies develop those sorts of questionnaires. One model we had in particular generated an outcome which is based on a triangle, and the apex of each of the corner of each of the triangle, each of the three corners, one represented, if you ended up squarely at the corner of the triangle, one of the outcomes was, keep trade secret, the other one was patent, and the other one was publish and release to the public domain. And that only ever happened, of course, if you'd agreed that, yes, it could be published as an academic paper, and no, we're not going to file a patent, we're not going to incur costs. So, but it was quite rare, in fact, that you ended up in any of the corners. But what it did do was weight, you got a visual outcome to show you where we, as a result of this developed questionnaire with the client, would suggest that particular product goes. And then, of course, so it was a visual outcome rather than a number, because, as I say, it was part of a triangle. So visual representation worked well for those clients that we developed that for. And, and it's not definitive. And it might be that the IP budget says, well, we've only got room for 5 patent applications this quarter, or whatever number it might be. And so you can look at your outcomes and say, well, okay, these are the obvious 5 that we're going to go for, because they're the closest to the patented one of them, the other ones. So, and anything else can be kept as a trade secret for the time being.
I really like some of these things we talked about with, for instance, with this triangle of, it's not always just, should it publish? Should it be a patent? Should it be a trade secret? What are the trade-offs? Of course, sometimes it's just budgetary, but I think, one of the things you were alluding to with the publications committee was that it could be both, right? It could be both published and patented, as long as it's done in the right order, of course. I do have one more question, more about just kind of strengthening. So how can we, who patent a lot in the software space in these industries that we are in, how can we work with inventors to strengthen the level of detail in the specifications for the software patent application? I'm especially interested personally in how you prepare a specification such that there could be a continuation or a divisional practice, depending on what part of the world you're in, and kind of mining things out of it later, especially with inventors that, as you kind of alluded to earlier, also don't love to write a bunch of things down because they are, coders, not writers. How do you get there?
Yeah, I think we've covered a few points leading up to this. And I think, but onto the specific, and it is down to training and engagement, culture, and communications, the various sort of rather nebulous factors. But how you get there, I think, initially is, having that point of contact. And if it's an individual engineer, software developer that's the lead or the IP champion or somehow, but that interview, sitting down and properly engaging with them, I mean, certainly in the early days, I think that's essential. You can't just rely on those ping-ponging written documents, emails backwards and forwards. And so that the interview, and I think one of the skills as a patent attorney, we aren't idiots, but actually being prepared to sit there. We've all got technical degrees, we've all got lots of qualifications, but actually being prepared to sit there with an engineer and genuinely recognize that, clearly they're the expert and that you're prepared to ask what might on the face of it be a silly question, and tell me about that. Can you explain that? And the point about, I think the thing I love about being a patent attorney is, learning new stuff and being told new stuff by engineers. They're clearly passionate about it. They want to explain it, and sitting down and listening and asking those potentially dumb questions, having the confidence to potentially ask those questions or potentially dumb questions is a skill on our part. And this is one of the things when I joined the profession, I must say, a bit of a personal beef, as a recent PhD graduate, I was coming into the legal sector and it was quite aloof in London. And this probably shouldn't go to air, but it was up its own backside, for want of a better expression. It was, and it wasn't helpful. It was there's a sort of relative arrogance. You think, well, we're a means to an end. We're not the end. It's the engineers and the companies that are generating innovation that's got to get to market. We're just a cog in that wheel of helping them generate a fantastic product, generate revenues, generate money to reinvest in that cycle for technical development. So that thing about the modesty, the confidence and the modesty, confidence to know that we can understand it if it's explained fully, appropriately, or whatever, and being able to sit there and challenge somebody with dumb questions and get the answer. I think there's no better way of doing that. And of course, hopefully you then build up, assuming your questions aren't really stupid, you build up a good rapport with these engineers, right? And they start to respect you and think, oh, well, Barnfather or Morris or Check can understand this stuff. That's the benefit of engaging with the client, isn't it? And helping them. And then next time around, it's better. So I think that personal touch and the personal conversation really will stand you in great stead. I'm not sure that's the only thing that there is. As I said, there was lots of other points we made earlier. But I think that's possibly the overarching thing. You clearly got to know stuff. You've got to do your research before you sit down, haven't you? And you've got to be aware of where the innovations might be and prompt them in the right direction, prod them in the right direction, and say, well, what was particularly clever about the way that you did that particular, what was particular about this particular process. So yeah, your research, academics, scientific engineering skill sets that we bring to bear, because I think certainly, again, might not be so prevalent in the US, but European perspectives, they do regard us as lawyers rather than hybrids, engineers, lawyers, and don't necessarily know that we've got, despite the fact you can look it up on LinkedIn or wherever, people see that, they necessarily know that we have got some technical competence, even though we might have, left the academics behind some time ago. But the fact is, we're working in the sectors, aren't we, constantly, and updating our own knowledge and understanding constantly. So, getting that confidence across for them to help you, as I say, I think is key.
Well, Karl, thank you for boosting our confidence in our abilities to answer these questions and our audience's confidence as well. Appreciate you joining us for this episode, sharing your experiences and thoughts, and I hope to be able to invite you onto a future episode.
No, thank you very, very much, both of you. It's been an absolute pleasure.
Thank you so much, Karl. This was so interesting. What a great podcast, guys. Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode,
feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.